You are watching the exact second a federal courtroom crossed a point of no return. This wasn't a dramatic objection. This wasn't a heated exchange. This wasn't even a controversial ruling. This was the moment a sitting federal judge realized that the people sworn to uphold the law inside his courtroom were actively violating it. And once that realization hit, everything unraveled at once. What happened this morning wasn't slow. It wasn't procedural. It was instant and irreversible. At 7:47 a.m. Eastern Time, an encrypted audio file quietly appeared online. No press release, no warning, no context, just a file name that immediately raised red flags across the legal world. W14, privileged, do not distribute. Within minutes, journalists covering federal courts noticed it. Within half an hour, legal analysts were scrambling to verify it. Within 90 minutes, the file had been downloaded more than 3 million times. By 9:15 a.m., the audio was being played, dissected, and replayed on every major news network in the country. That recording was not a rumor. It was not an anonymous claim. It was not speculation. It was Witness 14, the prosecution's most protected cooperating witness. The individual whose identity had been sealed by court order. The witness Judge Caldwell had gone to extraordinary lengths to shield. And what made this recording devastating wasn't just the content. It was the voices. Because the voices on that tape did not belong to criminals in hiding. They did not belong to outside fixers caught on a wiretap. They belonged to defense attorneys, officers of the court. That single fact alone turned this from a courtroom controversy into a constitutional crisis. Within hours, something almost unheard of happened. Federal marshals entered the courtroom and arrested defense attorneys in the middle of an active federal trial. When a federal judge orders officers of his own court taken into custody on live television, the system has already failed at the deepest level. So how did it get this bad? The audio recording is 11 minutes and 43 seconds long. Prosecutors say it captures a private conversation between three individuals now officially identified as Marcus Webb, lead defense attorney, Daniel Harmon, associate counsel, a third individual described as an intermediary connected to the defendant's business network. The tone of the conversation is calm, methodical, almost routine. That's what makes it terrifying. Just over 2 minutes into the recording, Marcus Webb speaks. There's no hesitation, no uncertainty, no concern about how it sounds. He says, the witness needs to understand that cooperation has consequences. Not legal consequences, personal ones. Make sure that message is received before Thursday. Thursday was the scheduled testimony date for Witness 14. That sentence alone is enough to destroy a career. But it doesn't stop there. Minutes later, Webb references sealed grand jury material. Details that only someone with authorized access could possibly know. Information explicitly protected by federal law. Then the third voice responds. And this is where the conversation crosses from unethical into criminal. The speaker confirms that pressure has already been applied to the witness's family. Not through lawyers, not through legal filings. Through real life. Employment, school enrollment, personal exposure. According to prosecutors, this wasn't theoretical. It wasn't metaphorical. It was operational. Legal experts reviewing the transcript say the language constitutes explicit witness intimidation. Then comes the money. Around the 8-minute mark, Daniel Harmon asks about payment. He doesn't sound nervous. He doesn't sound unsure. He sounds like someone confirming logistics. Webb responds calmly, explaining that the retainer covers everything, and that the funds were routed through a consulting LLC so nothing could be traced back. This is where speculation ends. Financial records subpoenaed early this morning show $847,000 in wire transfers from an offshore entity connected to the defendant's former business partner. The dates of those transfers align precisely with the discussion in the recording. January 3rd, January 6th, January 12th. The FBI moved fast. Their forensic audio unit authenticated the recording within hours. Voice pattern analysis identified Webb and Harmon with over 99% certainty. Metadata confirmed the recording date as January 11th, 2026, just days before it surfaced. But the most shocking detail wasn't the threats. It wasn't the money. It wasn't even the abuse of sealed information. It was who made the recording. Law enforcement didn't plant a device. This wasn't a sting. Court filings suggest the recording device was placed by someone inside the defense team itself. Investigators believe a junior paralegal with access to Webb's office had been cooperating with federal authorities for months. This wasn't an accident. This wasn't desperation. This was documentation. And by the time Judge Caldwell took the bench this morning, the damage was already done. He hadn't reacted yet, but he had seen enough. What happened next didn't just shock the courtroom. It permanently altered the trajectory of the case. And that moment, the exact instant the judge decided the line had been crossed, is where by the time Judge Caldwell took the bench that morning, the courtroom looked normal. Same benches, same flags, same attorneys seated at their tables. But underneath that surface calm, the case was already dead. At 10:47 a.m., a court clerk quietly approached the bench and handed Judge Caldwell a sealed filing from federal prosecutors. No announcement, no explanation, just a thick envelope marked confidential. Court observers say the judge didn't skim it. He didn't flip pages quickly. He didn't glance and set it aside. He read it, slowly, carefully, completely. For nearly 90 seconds, the courtroom was silent. No shuffling, no whispers. Even the gallery stopped moving. As each page turned, Judge Caldwell's expression changed, not dramatically, but unmistakably. His jaw tightened. His posture stiffened. This wasn't surprise. This was confirmation. When he finished reading, he placed the document flat on the bench. He didn't speak right away. He looked directly at the defense table. Then he said one word, "Marshals." For half a second, no one reacted. Then 4 U.S. Marshals stationed near the exits began moving toward the defense table at the same time. Marcus Webb stood up instinctively, as if muscle memory took over. He opened his mouth to speak. The gavel came down. Not lightly, not symbolically. Witnesses later said the sound echoed through the room like a gunshot. "Mr. Webb," Judge Caldwell said, his voice flat, "you will remain silent." Webb tried again to speak. The judge didn't raise his voice. "You are being placed under arrest." Gasps rippled through the gallery. The judge turned his attention to the others. "Mr. Harmon, Ms. Nakamura, do not move. Do not speak." Daniel Harmon reportedly went pale almost instantly. His face drained of color as he looked toward Webb, then toward the marshals. Priya Nakamura began visibly shaking. Court reporters noted her hands trembling as the marshals approached. Within 3 minutes, all 3 defense attorneys were in handcuffs. Their client, the defendant they were sworn to defend, remained seated at the defense table, completely alone, as his entire legal team was escorted out of the courtroom. That image is already being called one of the most disturbing moments in modern federal court history. Because in that instant, this stopped being a trial. It became evidence. The judge cleared the courtroom shortly afterward. But the damage couldn't be contained. Within minutes, word spread through the courthouse. Within an hour, the story dominated national news. By early afternoon, legal experts across the country were calling it unprecedented. And now the consequences are cascading. Every motion filed by the defense is under scrutiny. Every argument made in court is potentially tainted. Every private strategy discussion may now be evidence. Prosecutors are already signaling their next move. They are preparing to argue that attorney-client privilege was forfeited, not waived, not limited, but destroyed, the moment the attorneys allegedly crossed into criminal conspiracy. If the judge agrees, the implications are staggering. It would mean communications between the defendant and his own lawyers could be used against him in court. That is almost unheard of. Meanwhile, the Department of Justice has moved aggressively. Search warrants were executed at the law firm's primary office within hours of the arrests. Agents were seen carrying boxes of documents, hard drives, and computers out in broad daylight. Additional offices are reportedly under review. Sources say prosecutors are now focused on one phrase from the recording more than any other. Different team. Legal analysts believe that line suggests this wasn't an isolated incident. It points to a broader system, potentially multiple coordinated efforts to influence witnesses across different cases. If investigators can prove that, this case doesn't just expand. It transforms into a racketeering investigation. Witness protection authorities have also acted fast. Witness 14's identity, while still officially sealed, has been compromised. The threats discussed on the tape involved employment, family members, and schooling, triggers that require immediate response. Multiple relatives have been placed under emergency protection. Relocation procedures are already underway. And here's the part no one involved wanted to confront. If witness 14 becomes unreachable through fear, pressure, or disappearance, the prosecution's case could collapse regardless of how strong the evidence is. At the same time, the legal profession itself is in crisis mode. State bar associations have initiated emergency disciplinary proceedings. Suspension orders are expected almost immediately. Permanent disbarment now appears inevitable. Civil lawsuits are already being discussed. Former clients are reviewing past cases. Insurance carriers are assessing exposure. Industry analysts say the law firm involved may not survive the year. But the damage goes far beyond one firm. Because this forces a question the legal system hates asking. If elite defense attorneys were willing to threaten families, hide payments, and coordinate intimidation while hiding behind privilege, how often has this happened before? How many witnesses changed their stories without ever telling anyone why? How many cases were quietly shaped not by evidence, but by fear? That's the reckoning now unfolding. This isn't about politics. This isn't about ideology. This isn't even about this defendant alone. This is about whether the justice system can survive when its own officers become criminals. Defense attorneys play a critical role in protecting rights. Without them, the system collapses in one direction. But when that role is abused, when privilege becomes a weapon, the collapse happens from the inside. And that's what makes this moment so dangerous. Because trust, once broken at this level, is almost impossible to restore. As of now, the arrested attorneys remain in federal custody awaiting arraignment. Bail hearings are expected soon, with prosecutors likely arguing for detention based on the seriousness of the alleged crimes. The trial itself is suspended indefinitely. Judge Caldwell has scheduled a status conference to decide whether a mistrial will be declared, whether new counsel can even be appointed, and whether any part of the defense's work can be salvaged. Several prominent defense attorneys have already declined involvement, privately describing the case as toxic. And hanging over everything is a question with no comfortable answer. If the people sworn to defend the law are willing to break it so openly, what does that say about the system they operate within? This isn't just another courtroom scandal. This is a stress test for justice itself. And the next moves, by the judge, by prosecutors, by investigators, will determine whether this case continues or becomes a warning remembered for decades. As the courtroom emptied and the doors closed behind the Marshals, the reality finally set in. This case was no longer just about a corrupt defendant or compromised lawyers. It had become a question of institutional survival. Because once defense attorneys are accused of running a parallel criminal operation from inside a federal courtroom, nothing about the process remains untouched. Every safeguard designed to protect fairness suddenly becomes a vulnerability. And that's exactly where prosecutors are now pushing. Within hours of the arrests, federal investigators began reconstructing not just what happened on that tape, but how long it had been happening. According to sources familiar with the investigation, the recorded conversation was not treated as an isolated incident. It was treated as a window, a glimpse into a system. Investigators began mapping communications, payments, meetings, and travel records tied to the defense team. The goal wasn't just to prove intimidation of witness 14. It was to determine whether this was a repeatable method, a playbook, and the early indicators are deeply troubling. The consulting LLC mentioned on the tape wasn't dormant. Financial analysts reviewing subpoenaed records say it appears to have functioned as a pass-through entity, receiving large sums from offshore sources and distributing payments in smaller, structured amounts. Not random, not sloppy, deliberate. Investigators are now examining whether that same structure appeared in other cases handled by the firm over the past several years. And this is where the phrase "different team" becomes explosive. Because prosecutors believe it may refer to separate groups within the same firm, operating semi-independently, each responsible for influencing different witnesses across different cases. If that theory holds, this stops being about misconduct. It becomes enterprise-level crime. That's why racketeering statutes are now on the table. And that's why the Department of Justice quietly assembled a multi-district task force before the end of the day. Meanwhile, the defendant's situation has turned nightmarish. Victor Ashworth, who entered the courtroom that morning expecting another routine day of trial, now finds himself effectively defenseless. Every attorney he trusted is either in custody or under investigation. And any new lawyer who considers stepping in faces an impossible task. They inherit a case where every prior strategy may be tainted, where confidential discussions might be discoverable, where prosecutors may argue that nothing involving the former defense team is protected. Legal experts say this is one of the rare situations where a defendant can plausibly argue he's been catastrophically harmed by his own representation, even if he had no knowledge of their actions. But that argument cuts both ways. Because prosecutors are also evaluating whether Ashworth benefited from the intimidation efforts, whether the threats, payments, and pressure were undertaken with his knowledge, approval, or indirect encouragement. That's a line investigators are now racing to define. And here's where the paralegal becomes central. According to sealed filings, the paralegal who made the recording didn't come forward casually. They reportedly contacted federal authorities months ago after becoming increasingly uncomfortable with what they were seeing. Not one incident, not one conversation, a pattern. Prosecutors say the paralegal provided internal documents, calendars, and access points that helped corroborate the audio recording. That cooperation is one reason investigators moved with such confidence once the tape surfaced publicly. But the leak itself changed the calculus. Sources indicate prosecutors originally intended to introduce the recording in sealed proceedings, minimizing risk to the witness and maintaining control over the narrative. That plan evaporated the moment the audio hit the internet. Now everything is public, everything is accelerated, and containment is no longer possible. Inside the legal community, the reaction has been a mix of shock and fear. Shock at the brazenness of the conduct, fear of the precedent. Because this case threatens to blur a line the justice system depends on, the distinction between zealous advocacy and criminal conspiracy. Bar associations are now scrambling to reassure the public that this behavior is not representative of defense work as a whole. Ethics committees are issuing statements emphasizing that privilege is not a shield for crime. But privately, many attorneys are asking uncomfortable questions. How did this go unnoticed for so long? Who looked the other way? And how many warning signs were ignored because the lawyers involved were powerful, successful, and respected? Those questions don't have easy answers, and they're about to get louder. Because as investigators dig deeper, they're expected to notify other courts where the same defense team appeared. Judges will be forced to reevaluate past cases. Convictions, plea deals, even acquittals may come under scrutiny, not because defendants were innocent, but because the process itself may have been corrupted. That's the ripple effect now spreading outward. At the center of it all is Judge Caldwell. Legal scholars are already analyzing his response, calling it swift, decisive, and legally justified. Some argue it may have been the only way to preserve what remained of the court's integrity. Others say it signals a broader shift, a willingness by the judiciary to confront misconduct inside its own ranks publicly and decisively. Either way, his decision will be studied for years. Because federal judges are notoriously cautious about ordering arrests in their own courtrooms. Doing so means you're certain. It means the evidence is overwhelming. It means delay is no longer acceptable. And that's what makes this moment historic. As of now, the arrested attorneys are awaiting arraignment. Prosecutors are expected to seek detention, citing risk of obstruction and the seriousness of the charges. The defense firm's remaining partners are resigning or lawyering up. Clients are fleeing. And the case that began as a straightforward corruption trial has become something else entirely. A referendum on power, on privilege, on whether the law truly applies to everyone. Because when the people entrusted to defend justice start manipulating it from the inside, the damage isn't confined to one courtroom. It infects everything. And the question now isn't just what happens next. It's whether the system can correct itself before the damage becomes permanent. This story is no longer unfolding slowly. It's accelerating. And the next development, the next filing, the next arrest, the next revelation, could change the entire landscape of federal criminal law.